A black-crested macaque stared into a camera, pressed the shutter, and produced a photograph worth fighting over. The animal made the final exposure. The photographer supplied the equipment, and the internet copied the image everywhere. One answer said the photographer owned it. Another said nobody did. And a third said the monkey was the author. If a human prepares the camera but an animal creates the final frame, who does copyright law recognize? The photograph emerged from a wildlife trip to Sulawesi, Indonesia, where photographer David Slater was documenting crested macaques. In 2011, one macaque handled Slater's camera and triggered a series of exposures, including the famous close-up grin. The resulting image looked less like wildlife photography and more like an exceptionally confident profile picture. Slater published the photographs, licensed them, and identified himself and his company as the copyright owners. He did not deny that the macaque pressed the shutter. By claiming copyright, Slater was effectively arguing that his human contribution to making the image was legally sufficient. That distinction mattered because owning a camera does not automatically make someone the author of every image it captures. Copyright normally belongs to the person who contributes the protectable creative expression, not merely the person who owns the machine. The photograph spread rapidly through news sites and social media, where careful licensing analysis is traditionally conducted at tremendous speed. Then it appeared on Wikimedia Commons, the media library used by Wikipedia and other Wikimedia projects. Slater asked for the images to be removed, asserting that they were his copyrighted work. Wikimedia refused, reasoning that a non-human animal had taken them and no human author therefore held copyright. Wikimedia treated the images as public domain, meaning anyone could reproduce them without paying Slater. That created the first serious conflict, but it did not produce the lawsuit that eventually carried the monkey's name. The argument had already split into two separate questions that people kept blending together. First, had Slater contributed enough creative control to qualify as a human author? Second, if the macaque itself created the photograph, could the macaque own and enforce a copyright? Those questions sound similar, but they lead to very different legal outcomes. If Slater was the author, he might own the copyright. If the macaque was the author but animals could not hold copyright, the image might have no copyright owner at all. Then, in 2015, People for the Ethical Treatment of Animals chose a third route. PETA and primate researcher Antje Engelhardt filed a federal lawsuit in the name of a macaque they called Naruto. They sued Slater, his company Wildlife Personalities, and the publisher Blurb for copyright infringement. The complaint did not ask the court merely to declare the photograph public domain. It asked the court to declare Naruto the author and copyright owner of the monkey selfies. It also sought the defendant's profits, an injunction against further exploitation, and authority for Naruto's representatives to administer the copyright. So the legal theory was not that nobody owned the image. The theory was that the copyright belonged to Naruto and the humans had been using his property. The complaint alleged that Naruto independently examined the camera, understood the connection between the shutter and its effects, and deliberately took the photographs. At the dismissal stage, the court generally had to treat well-pleaded factual allegations as true. That meant the immediate issue was not whether Naruto truly understood photography. The issue was whether the Copyright Act gave an animal any right to sue, even if the complaint's factual story was accepted. PETA argued that the statute protects original works of authorship and does not expressly define an author as human. On that reading, the creative act should matter more than the species performing it. If Naruto independently created an original photograph, PETA argued, excluding him required adding a limitation Congress had not written. The defendants answered with a different rule of statutory interpretation. Federal rights do not automatically extend to every conceivable claimant, simply because a statute does not list every exclusion. If Congress intended animals to own copyrights and sue humans for infringement, the defendants argued, Congress needed to say so clearly. There was also an unusually direct problem sitting in the Copyright Office's official guidance. Its compendium states that copyrightable authorship requires a human being. Among its examples of works that cannot be registered is a photograph taken by a monkey. The guidance did not become binding law merely because an agency printed the perfect example. It did, however, show how the federal office responsible for registration understood the word author. In January 2016, the district judge dismissed the case. The court explained that the Copyright Act never mentioned animals, and that prior decisions consistently described authors as persons or human beings. The judge also relied on the Copyright Office's human authorship guidance as persuasive authority. PETA said excluding animal-created art conflicted with public interest in such work. The judge's response was essentially that this was a policy argument for Congress and the president, not a license for judicial improvisation. Naruto, therefore, was not an author entitled to sue under the Copyright Act. Importantly, this was a dismissal by a judge, not a jury verdict after a trial. No witnesses testified about the camera setup, and no jury compared Slater's contribution with Naruto. The court resolved the case at the threshold because the proposed plaintiff fell outside the statute. PETA appealed, which introduced a second legal problem before the appellate court even reached copyright. PETA claimed to act as Naruto's next friend, a representative suing for someone unable to appear personally. Federal law sometimes permits next friend litigation for people such as minors, incompetent persons, or habeas petitioners. It is not an unlimited permission slip for an organization to select a silent client and begin litigating. A proper next friend generally must be genuinely dedicated to the claimant and have a significant relationship with that claimant. The complaint alleged no history or relationship between PETA and Naruto. The Ninth Circuit said PETA's connection was no more significant than its connection with any other animal. The court also concluded that existing law did not authorize next friend suits on behalf of animals. That alone sounds like the case should have ended without another word. Federal appellate procedure. Naturally, located several thousand additional words. Earlier Ninth Circuit precedent had treated animals as capable of alleging the kind of concrete injury required by the Constitution. Bound by that precedent, the majority accepted that Naruto's alleged loss of copyright income was concrete enough for constitutional standing. In plain English, the court said Naruto's alleged injury could resemble a real case, while his legal right under this statute still failed. Constitutional standing asks whether there is a genuine dispute a federal court can potentially resolve. Statutory standing asks whether the particular law gives this particular claimant a cause of action. Naruto cleared the first barrier under binding circuit precedent and collided with the second. The Copyright Act did not expressly authorize animals to bring infringement claims. The appellate court applied a clear rule inherited from an earlier animal standing case. If Congress plainly grants animals rights under a statute, animals may invoke those rights. If Congress does not plainly do so, courts will not create the authorization themselves. The surrounding language of the Copyright Act reinforced the court's conclusion. The statute discusses an author's children, grandchildren, widow, and widower when describing inheritance and termination rights. Those provisions assume a legal author operating inside human systems of family, ownership, transfer, and succession. PETA noted that corporations can hold copyrights despite not being human beings. The court rejected that comparison because corporations are legal entities formed and owned by humans and already recognized as persons for many legal purposes. A corporation may lack a pulse, but it arrives with officers, signatures, duties, and a legal address. Naruto arrived with a remarkable photograph and no congressional authorization. In April 2018, the Ninth Circuit affirmed the dismissal. Its central holding was narrow but clear. Animals lack statutory standing to sue under the Copyright Act unless Congress expressly provides otherwise. The court did not hold a trial and decide that Slater personally created the famous frame. It did not adjudicate Wikimedia's separate claim that the image was in the public domain. It did not rule that owning the camera automatically transfers authorship from whoever presses the shutter. And it did not decide every possible question about human planning, selection, editing, or arrangement surrounding an animal-triggered photograph. The case decided that Naruto could not claim and enforce copyright under the existing federal statute. That difference is the part most headlines flatten into a cheerful sentence about a monkey losing copyright. Naruto did not lose a copyright the court first recognized. The court held that the law never gave him the statutory right to assert one. Before the appellate opinion was issued, PETA and the defendants announced a settlement and asked the court to dismiss the appeal. Slater agreed to direct 25% of future gross revenue from the images toward charities protecting crested macaques and their habitat. That was a private charitable commitment, not damages awarded to Naruto, and not a judicial finding that Naruto owned anything. The appellate court noted another awkward detail. Naruto himself was not a party to the settlement. The court refused to let the agreement erase the lower ruling and proceeded to publish its decision. One judge wrote separately that the entire case should have been dismissed earlier because PETA lacked valid next friend status. He sharply criticized the attempt to settle after argument while claiming both to represent Naruto and not bind him. The majority and concurrence disagreed about the procedural route, but neither accepted PETA as a proper next friend for an animal. The Ninth Circuit also granted Slater and his company entitlement to appellate attorneys' fees and costs. It sent the calculation of an appropriate amount back to the district court and did not announce a final sum in the opinion. No damages were awarded to Naruto, and the published judgment remained a defeat for the copyright claim. The story might have remained an eccentric corner of animal law if machines had not begun producing images, music, and text. The modern question is not whether a camera has opposable thumbs. It is how much human creative control must exist before machine-assisted output becomes a human-authored work. The Copyright Office has continued to apply the same basic boundary to generative artificial intelligence. Purely machine-generated expression is not copyrightable, while identifiable human selection, arrangement, or modification may still receive protection. In 2025, a federal appellate court separately held that an artificial intelligence system could not be the author of a copyrighted work. The United States Supreme Court declined to review that decision in March 2026, leaving the lower ruling in place without itself deciding the issue. That later case did not transform Naruto into an artificial intelligence precedent for every disputed output. It did confirm why the monkey selfie remains relevant. Copyright still begins by searching for human authorship. The answer to the opening question therefore depends on the human contribution the court actually examines. Preparing equipment may support human authorship when the person controls the protectable creative choices. But camera ownership alone is not the test. An animal that independently creates the final expression is not recognized as a copyright author under current United States law. If no human contributed enough authorship, the result may be an image that everyone can copy and nobody can own. The macaque created an unforgettable frame, but the law required a human author, and no amount of smiling could rewrite the statute.